All rise. The First District Court of Appeal is now open. All who have business before this court draw near. Give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case from the docket for oral argument this afternoon. The case of Tijuana Morris versus Orlando Munez, MD, et al. Counsel ready to proceed. You may approach counsel. Again, counsel, we allotted 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. 5 minutes, please, for rebuttal.
So noted, Madam Clerk. You may proceed, counsel.
May it please the court, my name is Courtney Brewer on behalf of the appellant, Tijuana Morris. This court should reverse the trial court's dismissal of Mrs. Morris's cause of action because Ms. Morris corroborated her pre-suit notice with the affidavit of a competent expert fully qualified under the relevant statutes. And the fact of Dr. Thompson, the expert in this case's qualifications, are fully reflected on the face of her affidavit and her CV. Turning first to the statutory requirements, which are plain on their face, under 766.2026, you have to be duly and regularly engaged in the practice of medicine, hold a healthcare professional degree, and also meet the requirements under 102 for our purposes, subsection 5 of that statute. And that requires an active and valid license, that you've conducted a complete review of the pertinent medical records, and that you are in the same specialty and have devoted professional time to the clinical practice of medicine of your specialty in the 3 years preceding the occurrence. I would note, just as the trial judge did in the first motion to dismiss hearing here, that it's not a substantial professional experience as in other parts of the statute. But one other thing to keep in mind is that any doubts, if there is any ambiguity in the statute, are to be resolved in the favor of the plaintiff of allowing access. It's a liberal construction that this court applies. So turning to Dr. Thompson's affidavit and CV, she met all of the requirements of the statute. She was licensed, she had reviewed the medical records, and most importantly, she stated in her CV, or in her affidavit, I was engaged in full-time patient care until March 2008.
So is that enough? I mean, anybody who just writes in an affidavit exactly what you just said, there can be no further engagement in the truthfulness of that? What if it were completely outrageous and obviously untruthful?
Your Honor, if there was something in here that was on its face conflicting, if she said
Does it have to be conflicting, or can it just simply be incredible?
Well, Your Honor, I think if it was something that could either needed further explanation because it didn't provide all of the information that the statute required, or that simply could not exist in the same realm. I mean, I think that going to law school and grad school as she did and practicing full-time patient care at the same time are not incredible. It sounds difficult, but it's not something that you would say there's no way that anybody could do that and she must be lying or there must be more to this story. Because she also...
But that's not, the trial judge didn't agree with that characterization. The trial judge did find that there was no way that she could deliver 400 babies in a year when she's attending law school or whatever else she was doing. That's what the judge found.
That's what the trial judge found. You mean you're talking about after the deposition was held. Well, the trial judge found that without any evidence to support that. Not a single item supported the fact that she couldn't have done that. She went to the deposition. She explained how it was she accomplished that. She said, yeah, it was difficult. I had to work a lot. It was very hard. But I balanced my work schedule with my law school schedule. I took classes in the morning and saw patients in the afternoon, and I was on call. And when I was on call in the evenings or on the weekends, if I had to be at the hospital, I took my books with me. I mean, she explained how she was...
She wasn't required to work full-time anyway, was she? It was
no,
professional time in the 3 years prior.
That's right, Judge,
So,
yes.
we haven't quantified whether that's 5 minutes, 5 hours, 5 days, we don't know.
Right. There's nothing in the statute, and certainly it should be, again, construed liberally in our favor.
Let me follow up with that, just to make sure I understand the scope of the statute. And I'm sure I'll be asking appellees the same question. You know, what if I'm a doctor and I'm engaged in the practice of law, clearly full-time, see patients, go to hospital, have call constantly, and then one day I stop, I never see a patient, I never go to hospital again, 2 years, 10 months later, I'm called upon to be an expert for pre-suit in a 766 action. Does it matter? I mean, it says during the 3 years immediately preceding. I was curious
Right.
if you have an idea about whether that means the entire 3-year period.
Well, I think that, again, it's a liberal construction. I think it would, if you had only practiced for 2 months of those, I still think, an argument could be made. That's certainly not the situation we have here, and I think the trial judge, both the first trial judge on this case and the defense conceded that the 8 months that she did retire before the 3-year period was up was not consequential, that it's not a continuous practice of medicine. In that situation, I mean, all it says is have devoted professional time to practice in the 3-year preceding occurrence. So I'm grateful that's not the situation that we have here, but if we did, I would still make the argument that that is what is included in the statute.
And would you point us to the revision that you mentioned in your reply brief?
Yes, Your Honor.
That's where we should look.
You mean as far as, the statute that applies is the 2011 statute. What I was pointing out in the reply brief is that some of the defendants have made much of the fact that the previous statute said same or similar specialty, and if you were in the similar specialty, then you had to also show that you had dedicated time to evaluating, diagnosing, or treating the medical condition that's the subject of the claim. And what I'm saying is that that portion of the statute does not apply when you are in the same
Does
specialty.
it not apply because, as you said, because she's in the same specialty, or does it not apply because the statute was amended in 2013?
It does not apply because she is in the same specialty. And in the reply brief, I pointed out a host of statutory interpretation reasons why that is the case under the 2011 statute. And one of those reasons is that, a recent amendment can clue you into what it was the legislature was talking about. And so the fact that they eliminated all of that when eliminating similar specialty certainly weighs in our favor. But I also think it's the most reasonable explanation. I mean, the whole point of this, the whole purpose of the statute is to ensure that you're not filing baseless litigation, that somewhere you have found a competent expert who believes that there is negligence here. And you want to ensure that the expert has a sufficiently current knowledge of the prevailing standard of care. And, if someone is in the same specialty as the defendant doctor, that is what the statute requires. So, we think it was enough with the affidavit and the CV. There is plenty of case law that talks about the CV and the affidavit being enough.
So, counsel, it's your position that the trial court erred in conducting an evidentiary hearing in this matter?
Yes, Your Honor. The trial court did not need to get to an evidentiary hearing because the CV and affidavit were enough to show.
What is our standard of review of the trial court's decision to conduct an evidentiary hearing in this matter?
The decision to conduct an evidentiary hearing is reviewed de novo, and I think the trial court's ultimate decision in this case is reviewed de novo. Obviously, before ordering any other discovery, that's a de novo standard under the case law. But I also, the defendants point to a lot of cases where the competent and substantial evidence standard applied after an evidentiary hearing, but that was where fact-finding was required. And here, there was no fact-finding. The facts were undisputed as to what she testified. The only thing on the other side is their speculation and their disbelief that she could have done what she said she did. But what it really comes down to, I think, here is more, what did she said? Does that qualify her under the statute? It's really a question almost.
Let me ask you a question. Let's, for purposes of our dialogue right now, presuppose that everything you said is accurate. And your argument is, I buy into it 100%. At what point can the opposing party or opposing counsel challenge the credibility of that expert, if ever? I mean, because it's very possible you will not use that expert at trial, right?
Right.
Or it's very possible you will never use that expert again except for the pre-suit block
Sure.
that's being checked. So if the opposing counsel is, basically, if I buy in 100% to your argument that the affidavit is binding and that the trial judge should not look beyond the affidavit, doesn't that put opposing counsel in a position where they can never challenge an affidavit by an expert that checks the pre-suit box.
Well, no, I mean, yeah, if the expert's affidavit, I mean, two fronts on that. If the expert's affidavit meets all the qualifications, if there's no obvious
Got it.
inconsistency.
It's 100,
Okay.
yeah.
So if it meets all of that, if the defendants did, I mean, we have pre-suit, they're supposed to be doing a reasonable investigation too. If they happen to look up our expert and, find out that she never practiced medicine in Austin in her life,
I
then.
recognize that on its face, your affidavit's good. They go, look, she's a qualified physician. As I recall, she practiced medicine for over 30 years. But on its face, they start questioning this, and I'm not suggesting
Sure.
that they're right or wrong, but they start, well, I've got some issues about whether you can go to full-time law school and work on a graduate degree and actually be practicing full-time medicine. I don't know that practicing full-time medicine is even required, frankly. But if they have some challenges, how can they ever raise that under your position?
Well, I don't think that they can certainly raise it if they want, but I don't think that the trial court should go beyond what the affidavit says in that situation. Okay. No, I don't think there would be. I mean, because the pre-suit requirements are not, this is not supposed to be a roadblock to bringing your case to trial. It's not supposed to test every single theory. They're just speed bumps to getting your case heard in the first place, getting you through the courthouse doors. And sorry, I lost my train of thought there for a second, but certainly in this case, when we went to the deposition, we did everything that the defense wanted. She swore that she did both things at the same time, and to the extent that the defendants wanted additional information, that was way beyond the scope of what the trial judge's order required. What the trial judge allowed to happen here was basically a fishing expedition to root out inconsistencies or possible bias, and he allowed really the defendants to turn this into the type of sword that the pre-suit period is not supposed to happen. None of the cases that they cite are like this, and before I sit down to save my time for rebuttal, I just wanted to address very briefly the 766.1026 requirements. So these are as to the defendant hospitals. Here again, we meet the statute. Dr. Thompson, she met the qualifications under 5, and by reason of her active clinical practice had
Counsel,
knowledge.
before you get there, let's assume, for the sake of argument, that Dr. Thompson's qualifications were unrebutted in terms of the pre-suit discovery. Can the trial court make a credibility determination of Dr. Thompson based on unrebutted testimony?
Well, the trial court has nothing to support its. I guess if the trial court is making a credibility determination, it has nothing to find that her explanation or what she has said is incredible. So I don't think there would be no competent substantial evidence in that situation to support the trial court's finding if this court goes to a competent substantial evidence standard, which again, I'd refer you, the brief talks about Oliveros. I think that case very nicely sums up why the de novo standard of review applies here. But in any event, we meet subsection 6. The affidavits in CV show that she had an administrative position at the hospital. It was fair to presume that she knew what staff are supposed to do and what they should tell the doctors, and she certainly confirmed it in her deposition via direct.
The trial court dismissed this case in part for the appellant's failure to comply with pre-suit discovery.
I disagree, Your Honor. I think that the trial court detailed the violations he found regarding how we failed to prove that Dr. Thompson met the qualifications under the statute, but his conclusion
Go ahead.
in the order is that we failed to meet the qualifications of the statute.
Well, at page 3 of the order, last paragraph, the court finds the actions of plaintiff's counsel were purposeful and designed to deprive the defendants of the ability to meaningfully participate in pre-suit discovery of the medical negligence claims against them, and as such was not in good faith. Again, was the plaintiff's alleged failure to comply with pre-suit discovery a basis for the trial court's dismissal of this case?
The trial court was buttressing its conclusion, I think, about why it was not going to give the plaintiffs another shot at proving her her qualifications. But even if this court gets to it decides it's a discovery violation, the trial court abused its discretion in dismissing this case on that basis. We complied. We were responsive to every discovery request.
And why did the trial court abuse its discretion in dismissing on that basis in this case?
Because we complied with what it was that the trial court and the defendants wanted us to show, which was that she was qualified under the statutory qualification requirements. I'll reserve the rest of my time for rebuttal, please.
Thank you. Counsel, we will add an additional minute to your rebuttal time. We'll also add an additional minute to the appellee's time as well.
Thank you, Your Honors. Cliff Higbee from Panama City, Florida. May it please the court. I represent Dr. Stephen Smith, a defendant in this matter, and we are going to split our time as between me and Mrs. Graves, so after about 7 minutes or so, 7.5 minutes, I'll step down. I want to follow up on some issues. It seems the panel appears to be have picked up on a theme that we proffered actually in our brief, and that is that it's our position that these two trial judges acted appropriately on this record and that they were not bound to accept at face value the affidavit of Dr. Margaret Thompson, the expert proffered by the plaintiff in this case.
Well, they didn't. They ordered, or not they, the trial judge ordered a deposition.
Correct, yes.
And opposing counsel at the deposition, pursuant to the limiting purpose of the deposition, took the position that the scope of the deposition was going beyond the limited purpose that the trial judge had ordered. And so let's even hypothetically conclude that they made a mistake, that they should have allowed that to go beyond. Dismissal seems to me as if it's an extraordinary remedy, and the trial judge very easily could have, instead of dismissing the case, made a determination that the appropriate remedy would be to allow further deposition of the physician expert for purposes of whatever. But it's not inconsistent with the trial judge's initial order that the purpose of that deposition was for a very limited purpose.
No question about it, Your Honor. And the inquiries, if you've looked at the deposition, and I would encourage the court to do so, Judge Patterson had read every word of that deposition when we got to the hearing, to the evidentiary hearing. And the problem that occurred, of course, was, and Mrs. Brewer was talking about how it was unrebutted. It was unrebutted. It was unrebutted. Well, there's a reason it was unrebutted.
Assuming for the sake of argument that Dr. Thompson testified as follows. She worked greater than $50 per week as an OB-GYN in 2006 through her retirement in March of 2008. That during that time, she handled calls for her own and other OB-GYN patients through the ER at North Austin Medical Center. That she explained how she managed to obtain her JD while working full-time as an OB-GYN until March of 2008. That she testified she took calls on weekends or asked another doctor to cover for her if necessary. She took night classes when possible. After her first year, she had flexibility in selecting her schedule to group her classes together so as to minimize the time she was out of the office and hospital. That she studied while at the hospital and on call and scheduled her patients around her classes. She also took an extra semester to finish. Now, assuming for the sake of argument that this testimony is unrebutted, then why is this testimony not sufficient to meet or comply with the duly and regularly engaged in the practice of his or her profession requirement of 768.202B?
Because the reason it was unrebutted, Your Honor, is we were deprived of the opportunity to inquire on what we would submit as a facially incredible testimony. We tried to get into if you notice on the affidavit of the expert, she says, I received my JD in 2007 and my master's in public administration 2006. I retired in 2008 due to arthritis. We learned that she had retired as a result of a disability. We tried to ask questions at the deposition about that.
So,
Mr. Brown completely shut us down at every opportunity.
So it is your position the trial court dismissed this case in part for the appellant's failure to comply with this direction
Absolutely.
regarding the discovery directed solely to Dr. Thompson?
Absolutely, and let me hit on that real quick. If you read Judge Lewis, 766, 200 and on, the part that addresses pre-suit discovery, all of the language in the statute is mandatory. To us, this is simply a statutory interpretation. If the plaintiff fails to, or if either party fails to cooperate, the court shall dismiss defenses, or it shall dismiss the complaint. It shall.
In that case, counsel, where a party's counsel is either partly or wholly to blame for discovery misconduct, our Supreme Court in Cozell versus Ostinoff established a set of factors to guard against unduly punishing the client for counsel's blunders. Assume, for the sake of argument, that the Cozell opinion applies to the facts of this case.
Yes.
Did the trial court apply the Cozell factors in dismissing the case, this case?
I submit that de facto the court did, but let me just say one thing about that. I think Cozell.
Your position is de facto the court did.
Pardon me?
Your position is de facto the trial court de facto
Yes, they
applied
found
the
that this
Cozell
was
factors.
willful, deliberate, contumacious, had been going on for the entire case, but this case is different from Cozell in one important factor, Your Honor, and that is all of this occurred during pre-suit, which is governed by 766, okay? Cozell was after a medical malpractice case had been filed, and it's during the regular course of the lawsuit, okay? And we would submit, and I think Mrs. Graves will agree with me, that Cozell, while we don't disagree, I mean, all the cases clearly say that the statute should be construed liberally. There's 20 years worth of cases that say that. We don't disagree with that. But this was not a mere technicality. And there are three cases, the Royal case, the Mellinson case, which is a first DCA case where Judge Nikki Clark was the trial judge, and the Fahey, I think, Brell case. There's Correa is another case. Correa, Royal, and Mellinson all point to the fact that misconduct during discovery can lead to dismissal.
Are you familiar with Judge Wolf's opinion in BAC Home Loans, LP versus Ellison, where he says express findings are required to ensure that the trial judge has consciously.
If Cozell applies, yes.
So your position is Cozell doesn't apply?
Well, I think Cozell can lend some guidance. I mean, we're not arguing with the Supreme Court, but I think,
Well, that's the
Your
first
Honor,
DCA case.
yeah, I think
The one
where we are.
Judge Wolf's case is the first DCA.
Correct. Yes. I think, I don't know that it's cited in our briefs, but I believe that's a fairly recent opinion, and I think I am familiar with it.
2014.
Okay.
What about Woodall?
Woodall, again, is not an issue that occurred, and if I may.
Just to refresh you, that is a case where
We
the
addressed
court
Woodall in our
specifically held
brief.
that Cozell applies to the 766 pre-suit.
Okay.
The second DCA.
I think in Woodall, the distinction is that it was a single instance of the plaintiff's attorney dropping the ball and missing a deadline or something like that. The spirit and intent of 766 is to encourage the free exchange of information so that a physician like my client can appreciate what he is being accused of, how he breached the standard of care, and what condition it was that he failed to treat.
In this instance, let's stay with this Cozell analysis, even if it's in pre-suit, and the second has said it should apply. But would you concede that dismissal is an extraordinary remedy?
I think it was, but I think,
Well,
Judge,
let's
I
follow.
think it is.
Is there another lesser sanction? Let me give you that maybe they should not have restricted responses. It's at the deposition of some of the questions, although in all fairness, I can see why they took that position, because we're talking about a pre-suit expert. Nonetheless, there was potentially some legitimate confusion. Why would not a lesser remedy be appropriate where the trial judge could say, listen, you're going back to the deposition, you're going to answer the questions, you're at this deposition, that's not an inordinate delay or an inordinate expense. Why would that not be more appropriate than in this instance, limiting the access of a plaintiff to the court system of the state of Florida because of some sort of impediment on that where the trial judge doesn't even apply the
I think the response we had to that in our brief, Your Honor, was this was a situation of 3 strikes and you're out, basically. Judge Fischel found in his order that the information that we were requesting could have freely and easily been obtained. He was so that was the first hurdle that was thrown down for us in pre-suit.
Did you ever file a motion to compel?
We were in pre-suit, Your Honor, and if
Well,
you read,
there you go. So there was. I mean, my point is, the judges. Typically, this would evolve with the motion to compel. You'd have a hearing on whether or not discovery had been complied with or not.
Well,
now all of a sudden you're going in, you're saying, in spite of the fact that you didn't evaluate the factors that the Supreme Court has said are appropriate, despite the fact that these have been applied to pre-suit criteria by the second, despite of all these factors, the appropriate remedy is dismissal and limiting the plaintiff's access to the trial court.
we believe that, again, these were not mere technicalities. This was a pattern of obstruction. It was a pattern of obstruction.
Which you never brought to the court's attention.
They didn't proffer a qualified expert.
You never brought it to the, what do you mean they didn't proffer a qualified expert? They had an affidavit and a deposition where the doctor testified that she had done this for 3 years.
And we were not allowed and we were not permitted to even cross-examine or get into anything that would challenge the credibility of the expert.
You did cross-examine her, didn't you?
Well, we did, but if you read the deposition, I can assure you there was one objection after another. And that was very frustrating.
Counsel, you're one of
I'm way past my time. I need to let Ms. Graves address you all. Thank you very much.
Thank you.
Trying to jump up so I could.
Counsel, regarding this matter, before you make your first point here, as I understand it, the motion to dismiss was filed. We had a hearing on the motion to dismiss. The court abated the motion to dismiss, directed discovery regarding Dr. Thompson's deposition. My question is, did counsel at any time amend their motion to dismiss subsequent to the deposition of Dr. Thompson regarding the alleged conduct of counsel during the deposition? Or did counsel make a motion to dismiss at the evidentiary hearing based on the alleged misconduct of counsel during the deposition of Dr. Thompson?
Gulf Coast filed let me just clarify that I'm here on behalf of the hospitals, and the hospitals have a different claim against them, which I'd like to get to, but to answer your question, Gulf Coast filed a motion to dismiss after the deposition that raised some of these issues, and it was certainly raised and discussed at length at the evidentiary hearing before Judge Patterson. So the obstruction of questions, our argument that we needed to get into the qualifications and we're not allowed to, that was raised at the evidentiary hearing, yes.
Was the motion to dismiss the proceedings made at the evidentiary hearing based on the conduct of counsel during the deposition of Dr. Thompson? Was the motion to dismiss raised by counsel for the appellees at the hearing based on the alleged misconduct of counsel during the deposition?
Yes, that was one of the grounds they raised for dismissal. They said she was not qualified and that they failed to comply with pre-suit discovery requirements. That was what was argued at the hearing, yes. Okay, so one thing I want to make clear about our clients, the hospital, is that it's a very different case against the hospital. Plaintiffs have made clear that they're suing the hospital for the conduct of nurses and medical staff. They're not suing on behalf of the physicians. That brings in another standard that needs to be applied in addition to 766-1025 and 766-2026. And that provision is 766-102-6. That requires that the expert show by reason of active clinical practice or instruction of students that she has knowledge of the standard of care of nurses. If you look at Dr. Thompson's Dr. Thompson's affidavit, it is completely silent about anything to do with nurses whatsoever. Okay, so nothing to do with nurses. There's nothing to take from that affidavit that has to do with nurses. It didn't identify any negligence of the nursing staff. If you look at what she said about it.
Was that the basis for the dismissal?
That was one of the bases, yes, sir. The last paragraph of the trial court's order as to the hospitals dismissed it under 766-102-6. In the affidavit, Dr. Thompson presents a background of facts that occurred that gave rise to her opinion, all of which, if you read carefully, has to do with the actions of physicians. Arguably, I will say that I can see how medical staff could be included in treating, but go to the opinion of the doctor then. The opinion is failure to make a diagnosis, failure to obtain lab studies, failure to recommend a consultation, failure to obtain internal medicine, gastroenterology, and neurology consults. That's nothing a nurse can do. A nurse under 463-003, which sets out what a nurse can do, can't do any of that. So we can't read the affidavit and say, oh, she is more than qualified to testify as to the standard of care of nurses. There's nothing in there. There's nothing in her CV that says she's qualified to testify about the standard of care of nurses. She says that she lays out her job experience, but there's nothing in there that says I'm qualified to testify as to the standard of care of nurses. Compare that to the Largy case, which was cited actually by plaintiffs, where the court found that it was sufficient because they said, I've done this in 3 years prior. They made it clear that they had a standard of review. I mean, she was knowledgeable of the standard of care of nurses. Now, I know what Ms. Brewer's going to say is that in her deposition, she said Dr. Thompson testified that she was chief of staff of a hospital and that she was head of a large unit, and so she oversaw hospitals.
Well, there were three things: chief of staff of the OBGYN department at a large medical center, chief of staff at a women's specialty hospital, and a member of a hospital-wide peer review committee.
You would jump, okay, from that assertion that her job, which we have no idea what she did during that job except to assume what she did, take a leap and say, okay, that gave her knowledge of what a nurse was supposed to do.
Also at her deposition, she testified that throughout her 30-year career, she supervised emergency room nurses while on call at the hospital and employed a nurse practitioner as well as other support staff in her clinical practice.
Yet, oftentimes, she said she supervised them, but not in an employment context. That means she's on the floor with them. She's worked with them. That doesn't mean, may I just finish this point, Your Honor? That doesn't mean that she, to testify to the standard of care of nurses, you have to say, what do they need to do in this situation? What did they do wrong? And that's not something that just knowing that she was chief of a hospital tells you. Not to mention the fact that in her deposition, she explicitly qualified her testimony as to the standard of care of nurses, saying, it depends. I don't know if I can testify as to the standard of care of nurses. I do know that I can't testify to the standard of care of nurses that are not in my specialty. She specifically said that. So nurses that don't specifically practice OBGYN, she can't testify. If you go back to her affidavit, the affidavit, who knows if that's an OBGYN? All of the things that she's saying, gastrointestinal problems, infection, not all of that had to do with OBGYN. When she was last admitted to the hospital, she wasn't pregnant anymore. Nothing to do with an OBGYN. Presumably that would be emergency room nurses or something else, but which she explicitly admits she had no qualifications to testify to. So I just submit to Your Honor that if you look to the affidavit, look to the CV, facially insufficient. You would be required to draw a big assumption as to what it takes to do that job. And then look to her deposition and the inconsistent testimony of, well, being chief of surgery allows me to supervise nurses. Well, what does that mean? Does that mean you can say, oh, well, they should have done this, gone up the chain of command, done something else, which is what they alleged in their complaint? Nothing shows that she had qualifications to do that. And her deposition, in context, shows that she all but admitted that she didn't, especially with respect to anything other than OBGYN nurses.
Thank you, Counsel.
returning to the point that first Ms. Graves just addressed, as far as what is required in the affidavit, the statute is pretty ambiguous about that, and I would just point out that Gulf Coast was required to provide an expert who met the same qualifications as our expert had to meet, and that in that expert's affidavit, they also didn't say that they were qualified to speak to the standard of care on nurses. And I think, Judge Swanson, you hit on it as far as the deposition. She answered all of their questions that they are now raising today as to what she was qualified to speak to. All of our claims relate to OBGYN. She is speaking to what the OBGYN nurses that would have seen her as she was coming in through the emergency room, what they should have done, who they should have referred her to. Moving on to Mr. Higby's points about the discovery violations. They weren't deprived of an opportunity to ask her all the questions. They took the deposition. She answered all of the questions. It was hours and hours long. She answered all of the questions that were in the scope of the trial judge's limited order ordering the deposition. Questions about her retirement, disability, what she's doing now, the fact that she's a litigation, that has nothing to do with the qualifications demanded of by the statute. She was responsive to the discovery violation. The things that we shut them down on, to use Mr. Higby's terms, were irrelevant information and overly burdensome duplicative information. I mean, they wanted her to put together a collection of the hours she had worked, a summary of the hours she had worked in a 3-year period. I mean, I think that would take inordinate man-hours and resources that we just don't require in the pre-suit process. Thank you, Your Honors. Please reverse.
Thank you, counsel, for your respective oral arguments. We stand in recess.
All rise.